I saw the final entry come down in the Cooley et al. V. Joseph Foreman, aka Afroman et al. Case. And I was just going to read through it because it's a bit of finality. A judgment entry in a case says, hey, the court, here's what happened at trial. The verdict is legally good. And I'm going to let you know if there's any costs or remedies that are being awarded to the parties. And I'm going to sign off. This is going to be a final entry. It's what parties would be able to appeal if they choose to appeal. It starts the timeline. So any timelines on how long you have to file a post-judgment motion or to file an appeal, the clock starts when this judgment is entered. So I thought we'd just read through it quickly. And then I got to the end and I'm like, wait, what is this? So let me show you guys what I'm talking about. So we have on March 20th, so the entry date was yesterday, in the Common Pleas Court of Adams County, Ohio, Sean Cooley et al., the plaintiffs, versus Joseph Foreman et al., the defendants, Jonathan P. Hein, the judge by assignment. This matter came before the court on the 16th, 17th, and 18th days of March, in the year of our Lord, 2026, for jury trial, pursuant to notice in the following counts in the amended complaint filed on May 10th, 2023. So count 3, invasion of privacy, false light publicity, and count 5, defamation. Prior to jury selection, plaintiffs dismissed count 4, invasion of privacy. The plaintiffs were represented by Robert A. Klinger, they spelled his name wrong, and Natalie Gretzler. Joseph Foreman was represented by David Osborne, Jr. Thereafter, the court and counsel examined the prospective jurors under oath until a panel of 8 jurors and 2 alternate jurors was selected. The court then administered the oath to the jurors and stood for the Pledge of Allegiance. Counsel for both parties made opening statements. Plaintiffs then presented their case through 10 witnesses. Numerous exhibits were admitted. Plaintiffs rested their case. A defense motion for directed verdict was overruled. Defendant presented his case through 1 witness and several exhibits. Rebuttal testimony was not offered by the plaintiff. Mr. Klingler and Mr. Osborne made closing arguments. The court then instructed and charged the jury. The alternate jurors were excused. The jury retired to deliberate their verdict. After approximately 6½ hours of deliberations, the jury returned written and signed general verdict forms. On all claims against the defendant, the jury found in favor of defendant Foreman. The jury was then discharged. Based on the verdicts, injunctive relief, as requested in count 6, cannot be granted since such relief is not a separate cause of action. And the site here was 2, Collins v. State of Ohio and Veller v. KB. Therefore, this count must be dismissed. So again, injunctive relief would have been, let's say there was a favorable verdict. The court could have issued an injunction saying, hey, Mr. Foreman, you cannot continue doing this action anymore. But since the jury was favorable to Foreman, we don't have that here. It is therefore ordered and decreed, and this is the part that I think is interesting, that judgment is entered on behalf of the defendant, right? This matter is dismissed. Based upon the relative merits of the case and the justiciability, I never know how to say that, of the claims, costs are divided 1/2 to plaintiffs and 1/2 to defendant Foreman. Final appealable order, signed here by Judge Jonathan Hein. So I'm like, okay, this seems like the judge must be using his discretion. How does this work in Ohio? Because on its face to me, one party prevails wholly, entirely, everything's favorable for the defendant. But the court says here, well, based on the merits of the case, I'm going to split the cost between the plaintiffs, 7 of these plaintiffs, and the defendant, which is Joseph Foreman and a couple of his companies. Some of the companies were just written in as John Doe's 1 through 3. So let's look at Rule 54 for Ohio. This deals with judgment costs. Down here, the section for costs reads, except when express provision, therefore, is made either in a statute or in these rules, costs shall be allowed to the prevailing party unless the court otherwise directs. So I think we use this discretion here, and Judge Hein did not miss the opportunity to say, based on the merits of this case, I think the parties should split any costs incurred upon the courts for which these parties will now have to pay for bringing this case forward. So, do you think that's fair? I don't think it's a good time. Let me know what you think. Hope you guys are all doing well. Take care.